Welcome to meeting number 103 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Standing Order 1083H and the motion adopted by the committee on Wednesday, December 6, 2023, the committee is resuming today its study of the federal government's use of technological tools capable of extracting personal data from mobile devices and computers. Today's meeting has taken place in a hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application.
Again, and especially our guests, that not to put the earpieces next to the microphone because it could cause feedback for the interpreters. So just be mindful of that. And I would now like to welcome our witnesses for today. From the Competition Bureau of Canada, Pierre-Yves Gay, Deputy Commissioner, Cartels Directorate. Mario Mainville, who is the Chief Digital Officer, welcome. From Shared Services Canada, we've got Daniel Mills, who is the Assistant Deputy Minister, Enterprise IT Procurement and Corporate Services Branch. Also Scott Jones is here, who is the President. And from the Transportation Safety Board of Canada, we've got Luc Cassot, who's the Director General of Corporate Services, and Kathy Fox, who is the Chair. Welcome, everyone. We're going to start with the Competition Bureau of Canada. You have up to 5 minutes to address the committee on this subject. Please go ahead. Start.
Bonjour, merci.
Good morning, Mr. Chair, and members of the committee. Thank you for the invitation to appear before you today. My name is Mario Mainville, and I'm the Chief Digital Officer at the Competition Bureau. Joining me today is my colleague, Pierre-Yves Gay, Deputy Commissioner of the Cartels Directorate. The Competition Bureau is a law enforcement agency that protects and promotes competition for the benefit of Canadian consumers and businesses. We administer and enforce the Competition Act by investigating and taking action to address anti-competitive business practices that harm consumers, competition, and our economy. We investigate criminal offenses such as price fixing, bid rigging, and mass marketing fraud, as well as civil provisions such as deceptive marketing practices and abuse of market power through restrictive trade practices. We also review mergers to ensure that they do not substantially harm competition. Finally, we advocate for pro-competitive government policies and regulations. It is solely within the context of investigations that the Bureau uses the technological tools at issue in the committee study. The targets of these investigations can be sophisticated firms or individuals operating in a deliberately covert or fraudulent manner. Rapidly advancing technology may act as a vehicle permitting users to communicate with others to implement possible anti-competitive conduct, and can assist in the perpetration of anti-competitive conduct while acting as a storage device to house information related to anti-competitive activity. In these cases, the Commissioner may apply to the courts for a search warrant in order to gather all necessary information.
Is that the Competition Bureau cannot make a decision to search a party's electronic data on its own authority without consent. The Bureau must submit a court document setting out the grounds justifying the issuance of a search warrant and the need to search the computer system. The court could then decide to authorize the Commissioner to conduct a search of the identified premises and to copy or seize certain records or other things for examination. Our use of these tools are therefore limited by the scope and the conditions outlined in these search warrants. The Bureau recognizes the importance of respecting individuals' privacy rights while executing a search warrant. The issuance of a search warrant by a judicial authority is a safeguard to ensure that searches are conducted with proper legal authorization. Law enforcement agencies are expected to handle and manage the personal information obtained during the investigation responsibly and in accordance with law and constitutional principles. Privacy considerations are relevant, and the Bureau has policies and procedures in place to ensure compliance with privacy principles and legal requirements. The Bureau works closely with legal counsel from the Department of Justice to ensure that our practices align with both criminal law procedures and privacy obligations. Additionally, any subsequent use, retention, disclosure of information collected during the execution of a search warrant is governed by Government of Canada policies on retention and disposition. With that, we look forward to discussing these tools with you today. Thank you, and we welcome your questions.
Thank you, Mr. Mainville. Next, we're going to go to Shared Services Canada. You have up to 5 minutes to address the committee. Go ahead, please.
Mr. Chair and members of the committee, I'm very pleased to be here to set the record straight regarding Shared Services Canada's use of technological tools to extract information from government-issued devices. Avant de commencer, je tiens à reconnaître que nous sommes réunis sur le territoire.
Before I begin, I'd like to acknowledge that we are gathered on the traditional unceded territory of the Algonquin and Anishinaabe people. With me today from Shared Service Canada is Daniel Mills, ADM of Enterprise IT Procurement and Corporate Services. As you're aware, Shared Services, SSC, is responsible for providing the foundational IT infrastructure for the Government of Canada. SSC is committed to improving the digital services that it provides. The department also has a significant role to play in ensuring the security of Government of Canada information while respecting the requirements of the Privacy Act.
Social media coverage referenced spyware. I want to assure you that under no circumstances is this an accurate description of the tools used by SSC. Departments across the Government of Canada, including Shared Services, use digital forensics tools to support administrative investigations. These tools are essential to our ability to investigate and conclude investigations that I, as Deputy Head of SSC, am authorized to conduct under the Financial Administration Act. Investigations happen only when there is a credible allegation of employee wrongdoing and to ensure the security of government networks upon which Canadians depend. Impacted employees are always made aware of the conduct of these investigations, and procedural fairness is ensured. Examples of administrative investigations could include suspected inappropriate website browsing on a government-issued device, malicious software installed on a government-issued device or network, or the unacceptable use of departmental electronic networks and devices contrary to the policy. Dans ces circonstances, j'ai le pouvoir de mener une enquête.
Under such circumstances, I have the authority to conduct an investigation, and our technical experts need these tools to do the work thoroughly and fairly while protecting the privacy of employees. We take the protection of the privacy of employees extremely seriously, and we use digital forensic tools very judiciously.
Investigation follows a very strict standard operating procedures and is taken under the direction of Shared Services Chief Security Officer. Investigations have a clear mandate and scope, including assurance of independence and impartiality in data collection. The digital forensics tools used to conduct an administrative investigation are used in tightly controlled environments. Government-issued devices, and only government-issued devices, are brought to a physically segregated secret-level lab where the tools are then used to conduct analysis. Only information necessary for the investigation is included. In addition, Mr. Chair, we also use these tools for legitimate operational purposes, such as to accelerate the retrieval of information to respond to requests faster under the Access to Information Act and the Privacy Act. From a privacy and protection of personal information standpoint, I take the Department's responsibility for personal information in SSC's custody very seriously. We have well-established standard operating procedures to protect privacy and embed trust in SSC operations. This is absolutely paramount. These digital forensics tools are used to analyze large quantities of data and information in digital form. Mr. Chair, I'd like to add that the Government of Canada has purchased these digital forensics tools for many years. When Shared Services was first created, the purchase of these tools was centralized at SSC to leverage the Government of Canada's buying power and to consolidate the number of smaller contracts that were prevalent across the government. As the IT service provider for the Government of Canada, SSC has put in place contracts to acquire these capabilities, allowing other federal departments and agencies to use our contracts to procure them in support of their operations. Nous sommes conscients que l'utilisation des outils d'investissement.
We are aware that the use of digital forensic tools can raise privacy and ethical concerns. That said, SSC takes the protection of information, the privacy of employees, and the security of Canadians very seriously. I'll be very pleased to answer your questions. Thank you.
Jones, pour la prochaine.
Then the next statement will come from the Transport Safety Board. You have 5 minutes to speak to the committee.
Chair, members of the committee, and I'd like to thank the committee for inviting the Transportation Safety Board of Canada to appear today. And first, I'd like to take a moment to explain who we are and what we do. The TSB was created in 1990 by the Canadian Transportation Accident Investigation and Safety Board Act, the CATASB Act. The TSB is an independent federal agency with a statutory mandate to advance transportation safety by investigating transportation occurrences in the federally regulated air, marine, pipeline, and rail modes of transportation. Transportation occurrences encompass both accidents and situations that, if left unattended, could reasonably lead to accidents. La mission du BST est énoncée à l'article.
The TSB's objects are set out in Section 7.1 of the CTAISB. The TSB's key objectives are to advance Canadian transportation safety by conducting investigations into the causes and contributing factors of transportation occurrences and identifying safety deficiencies, making recommendations to reduce or eliminate any such safety deficiencies, and reporting publicly on its investigations and findings.
Discretion to investigate any transportation occurrence for the purpose of carrying out these objects. The TSB's policy is to investigate occurrences that have a reasonable potential to result in new lessons learned that can lead to safety actions or that generate a high degree of public concern for transportation safety. The TSB's investigations and its resulting reports highlight issues that federal regulators and the transportation industry must address to reduce risks and safety deficiencies in Canada's transportation system. The TSB is independent and reports to Parliament through the President of the King's Privy Council for Canada. Conformément à son mandat à titre d'organisme
In keeping with its mandate as a safety investigation body, it is not the function of the board to assign fault or determine civil or criminal liability. And Section 7.4 of the CTAISB provides that any findings it makes are not binding on the parties to any legal, disciplinary, or other proceedings. The TSB is not a regulator, nor does it make administrative decisions.
Today, to discuss the use of data, I'd like to touch briefly on our own process for collecting and using data. The CATASB Act creates a number of privileges and evidentiary rules that are intended to ensure that the TSB has access to the information it requires in the context of its investigations. Pursuant to Section 19 of the Act, in the context of an investigation, wreckage and other items relevant to the occurrence are collected based on reasonable grounds. These items are examined and tested for the purpose of the investigation. Special tools are often needed to recover pertinent data, which comprises mainly technical information, such as any data recorded and displayed in the instrument panel and onboard computers, the position of switches, gauges, and actuators, GPS data showing longitude, latitude, and altitude, accelerometer data, which provides the exact position, orientation, as well as information on speed, acceleration, and vibration. Relevant data can include moments prior to and throughout the occurrence. Cette information est nécessaire pour déterminer la chronologie.
This information is necessary to determine the sequence of events of a transportation occurrence and ensures the TSB's fulfillment of its mandates, except for voice recordings, such as cockpit voice recordings or locomotive voice and recordings. As per Section 20 of the Act, all items collected in an investigation are returned to its owner.
Body, the TSB handles a variety of sensitive information, and it is the TSB's top priority and statutory obligation to protect personal information collected in the context of its investigations. For example, the TSB is required to always intervene in court proceedings to protect its privileges, such as witness statements. We are committed to updating our PIA for our investigation program to ensure that it is inclusive of all current technologies used to deliver on our mandate. And the TSB welcomes the opportunity to discuss with the committee how it has always protected personal information in compliance with the CATASB Act and the Privacy Act. Thank you.
Okay, so thank you, Ms. Fox. Just for the benefit of the committee, we did get off, obviously, to a late start. I'm going to try to keep it within the timelines. We're going to have time for a first and second round, probably ending up at 2.5 minutes. I understand that I want to respect the time of members as well, because I know that there are a few of you who have indicated that you've got other meetings after this meeting. We do have to deal with committee business. As I've mentioned, I understand that there's a desire from some members of the committee for a trip. We're on a deadline. We have to submit any request to the liaison committee by the 16th. So I do need to leave time for some committee business. So we're going to start our first 6-minute round. And just for the benefit of the guests, I'm old school. I don't like going through the chair. Deal directly with whoever is asking the questions. And that'll be Mr. Kurek for 6 minutes starting off. Go ahead.
Thank you very much, Mr. Chair, and thank you to our witnesses for being here today. And I had shared the advice with the other witnesses that we had before the committee earlier in terms of being proactive about privacy impact assessments and whatnot. I would encourage all of you, both your superiors and subordinates, pick up the phone. The Privacy Commissioner has made it very, very clear that he is happy to engage with you in whatever way possible. I am curious, though, Mr. Jones, I have a few questions just about how, because Shared Services Canada, it's a unique a part of how information and technology works across government. So I am curious. We've talked a lot about the use of these tools, but I'm a little bit curious about the tools itself. But emails, for example, if an email is sent from a government device, if that email is deleted, is there still a record of it somewhere?
Thank you for the question. From a government device on a government account, the email goes to the server. There's a record maintained of that email. So just so that I understand, even if the user of a particular device was to delete it off of their phone or off of their computer, was to press the trash can and even empty the trash can, would there still be a record somewhere of that email that was sent? There would be. It would be on the server to say that an email was sent on this time, this date, and the metadata associated with it.
Okay, so and then it's pretty straightforward then, I think, with emails. But is there records of other types of communications, things like phone calls, text messages, accessing the internet, that sort of thing? Is there similar metadata or specific data that shared services would keep?
For the mobile phones, it is directly with the telecommunications provider, so those records would be retained by the telecommunications provider. I would have to verify if we have access to calls made to the metadata associated with the call. We definitely don't have access to the calls made. My understanding is no, but I'd have to reconfirm that with our team just to see if there's some arrangement. But we wouldn't have access to text messages or the calls. They would only be on the phone.
So when it comes to the data, and we'll go back to emails as the example, it exists somewhere. So in terms of being able to access that information, for access to information requests, administrative investigations, which you've referred to, that information wouldn't be hidden even if it's no longer accessible by a government employee, for example. Am I interpreting that correctly?
So if the email was deleted because it had no records value, it wasn't loaded into the official record system, it was deleted from sent, et cetera, there would still be the record, and anybody who received it would still have a copy of it. But the record that the email was sent would still be in the system logs.
Okay, so So, Mr. Jones, the Auditor General, in what was a bombshell investigation just recently, talked about missing documentation for non-competitive contracts. So, I'm paraphrasing here, but it says that the documentation was missing from initial conversations. So, the Auditor General didn't get access to that information. But if emails were sent, it would still exist somewhere in government servers, record keeping. Is that a fair assumption to make?
So there should be a record of the sent, the fact that an email was sent.
Right.
What's exactly in that metadata and in that record, we'd have to check.
Okay.
I haven't looked at that for about 20 years in my career. So.
Okay. So, but if we were to dig into it, just because the Auditor General didn't have access to this information, if there was information that was sent from a government server, a government email, it would exist somewhere. You'd be confident of that? Am I?
I would need to verify exactly if you're saying, does the email itself exist?
Right.
Once it's sent, it will be, whoever received it will have a copy of it. Now, whether they delete it or not, the record would be the record of the event that an email was sent. Would be in the records. I'd have to confirm exactly what's stored in that metadata. I just don't know offhand.
Sure. I appreciate this, Mr. Jones, because it's interesting in the context of the fact that the Auditor General was unable to access this information, said that there was missing documentation and whatnot, and now it would lead one to the inevitable conclusion that maybe tools like what we're discussing here today are required to actually get answers. That a cover-up seems to be the obvious conclusion that certainly many Canadians, and I being one of them, would jump to in terms of the fact that practices were not followed, but it seems like the evidence certainly should be there somewhere. So, with that, I think I'm pretty much out of time there. Okay, so when it comes to the use of these tools, have you ever been asked to utilize these forensic tools for purposes of finding information that has been lost from government agencies, departments, or independent officers of Parliament?
Very quick response.
I would have to verify. I can't think of an example where we've used them in that manner.
Thank you.
Get back to the committee on that.
We can certainly do that.
Thank you very much.
Thank you, Mr. Kirk. Mr. Housefather for 6 minutes.
Thank you. Thank you very much, Mr. Chair. I'm going to come back to the subject that I think we were going to gather here today to talk about whether these tools are taking information and using them in a way that nobody anticipated. And I'll start with Shared Services Canada. Mr. Jones, nice to see you again. Mr. Mills. Shared Services Canada was created, if I remember, in 2011. And it was created out of different departments. The technology we have at issue, was that in the possession of Shared Services Canada in 2011?
That the technology we're talking about would have been transferred
Yep.
as part of the amalgamation of the 43, along with the procurement authority, to amalgamate those together. But we inherited the tools that we're talking about.
So these tools are long-standing. They're not new. You haven't, and you haven't bought them since 2015. They were there before 2015.
We've continually renewed the contracts, but those tools were in place during the creation of SSC.
Are you using those tools to spy on Canadians?
Absolutely not.
Can you advise us, is there any mechanism through which you use those tools when the device itself that you're extracting the information of is not in your possession?
We don't use those tools in anything other than a physically separate laboratory where we have the device in our possession, and it's a government-issued device as well.
Right. And then when you take the device, are you putting spyware and malware on it so you can spy on that device afterwards?
Absolutely not. Never.
And are you only securing the device if you have a warrant or if you have consent of the person involved?
So when we perform an administrative investigation, we do that with the full knowledge. The person knows that there's an administration investigation, but it is a government device, so we do it under that authority from the Financial Administration Act. It is not that these are never the first tools we use, though. We only go to these tools when they're necessary to confirm or to disprove the allegations that have been made.
So the average Canadian sitting in Winnipeg or in Montreal or in Vancouver can know with certainty that Shared Services Canada is not spying on their phone right now?
Absolutely. That would be completely contrary to our mandate and code.
Perfect. So let me ask the same questions of the Transportation Safety Board. Can you please assure me that you're not spying on Canadians with the extraction tools that we're talking about?
We are absolutely not. We are using the tool in the context of our mandate to conduct our investigations, and primarily with the consent of the proprietary, of the owner.
The consent or presumably a warrant of some type?
We can issue a warrant through after a request of the Justice of the Peace. We've never had to use a warrant for that because most of the time we get it through consent or on-site or through first responders.
And it would be the same in your case, that the extraction process would require you to have the device in your possession, correct?
Correct. We have the device in our possession. It's downloaded to a standalone computer. It's not on a network. It's at our laboratory. It's password protected as well as it has very limited access to it.
And you don't download software onto the device. You don't put malware. You don't put spyware. You don't put anything on the device that will allow you, after the person resumes having control of the device, you to know what they're doing or spy on them in any way.
Absolutely not. We do not keep the information that we downloaded except for that is absolutely required for the investigation, and we return the device intact to its owner or representative.
Perfect. And I imagine in both cases, because I know it's true at Shared Service Canada, in your case as well, that those that have access to the information is a small, limited group of people who have been properly trained on what they're supposed to do in terms of protecting privacy rights.
That is correct.
Thank you. Can I ask the same question of the Competition Bureau, please? With the same general questions, could you sort of respond to them?
We only use the tools in question with a search warrant that's been authorized by a judge, with the exception of one instance where there was consent and a consent agreement was drafted. So that's only happened one time. We don't spy on Canadians. We don't install.
Rassuré parce que j'ai dit ça en anglais. Donc, si je suis
If I'm in Quebec or in Trois-Rivières or Baie-Comeau or Montreal, you can't know. The Competition Bureau doesn't do any spying on my telephone? No, we don't have any spy software for those items that we seize. The same when we do seize items, we cut off the connection. We can't even connect with the cloud because we have to protect the information. That's part of our mandate, so we don't do any spying on Canadians. Same question. If you were to take my telephone because you were mandated to do so by the court, you don't put any spyware or malware on my. You when you hand my phone back, you tell me what I've done, and the only way that we can look at what's on it is to have the equipment in your possession. Is that true? You talked about a private laboratory. Yeah, it's a completely standalone laboratory. It's detached from the Government of Canada and from the Competition Bureau.
Right done.
30 secondes.
30 seconds.
Monsieur Housefather, en parlant de...
Thank you, Mr. Housefather. And speaking of Trois-Rivières, we have Mr. Villeneuve. You have 6 minutes. Thank you, Mr. Chair, and good morning and welcome to all the witnesses. I'm pleased to have this opportunity to clarify the situation. As you know, we're here today as a result of what occurred with CBC that mentioned that 13 organizations and departments, including yours, had not done any assessments with respect to privacy. So I'll ask each and every one of you the questions. Have you done anything to jeopardize privacy? Mr. Mainfield, no. Mr. Jones, no. But we did create the administrative investigation program. But you don't have any assessment with respect to privacy. There has a program, but we began the evaluation process. Ms. Fox, yes, we do have an evaluation of our program, but we didn't do any evaluations per se further to a conversation we had with the commissioner, but we decided to update or evaluate our programs. But up until now, we've been doing this type of work for a long time, and we haven't seen the need to do an evaluation since we already had an evaluation, a program evaluation done? And the commissioner, did he recommend that you do this evaluation, or did you feel that your program was adequate? The commissioner said that it would be advisable to recheck our program. Have you begun the work? Yes. Mr. Menth, I'll go back to you. So you haven't done anything, an evaluation with respect to privacy. Why not? Our program predates the directive with respect to privacy. That doesn't mean that privacy is not important to us, but we had a program in place before the program was put in place, so we haven't had to do any major changes to a program. Our program has been around since 1996, and we already had a tool that enabled us to do our job with respect to BlackBerries and flip phones and smartphones. But that being said, further to the testimony from the Privacy Commissioner, further to the news that came out in December, we contacted the Privacy Commissioner, and we have started taking measures. So you have started taking action with respect to an evaluation. The forensic program in itself. Are you evaluating the tools or the program? The way that I understand it is that the program, well, we can manipulate the private data, but the tool does the same job. It's not the tool that necessarily needs to be evaluated. So the recommendation is that we evaluate the activity or the program, and we decided to do it at a higher level and to look at the whole forensic issue. Between 1986 and 2010, between 2010 and 2024, the world's changed. We can all agree that the internet has really changed things, and the capacity of our phones now has changed. You also mentioned that you need a legal or judicial authorization, but that doesn't replace the. Why the delay? That's a very good question. One thing that hasn't been mentioned to date, because I've been following your proceedings here. In those periods that you alluded to, a lot of case law has been created, and we're going to adapt to it. If we use a search, if we need a search warrant now using the same criteria prior to 1986, the judge will refuse to do so. So there's a lot of CASWIRE has made us adapt our work. We have to now explain to the judge so that he trusts before he signs a search warrant. He has to know how we're going to use the data. And as the case law comes forth, we have to look at what's going on in the public sector, the private sector. My time's limited. So the case law and the search warrant doesn't replace the case law. I agree with you. Mr. Jones, you were the channel that enabled us to get these tools. When there were requests for such tools, you decided to procure them. Do you have any concerns with respect to privacy as a supplier of tools? Yes, thank you. Purchasing is one thing. It's how you use a tool. That's what's really important, because you can use tools in several different ways. We use the tools in order to collect information, in order to, if I may, if the Competition Bureau asks you to procure tools, they go through you because you're shared services. But what about, no, and that's not your responsibility as to how they're going to use it. So your policies pertain to your operations. Yes, thank you, Mr. Vilmer. Mr. Green, 6 minutes.
Thank you. Just following up on that, and to make sure that I'm clear, Mr. Jones, Earlier, you had stated that your department consolidated contracts through which other departments would use the technology. Is that correct?
That's correct.
And so in that, you would be responsible for the procurement, but not the implementation of the technology. Is that correct?
That is correct.
What would be the purchase order line on this type of technology? Maybe Mr. Mills?
I don't know, Dan, would you?
Yeah, no.
We'd have to get back to you. It would just be, we would have a typically what I've seen in the past, something like this would have kind of a standing offer. We would say, these are available, we've competed this, and then it would be a
How
request.
often have they been, so we know of 13. How many times, Mr. Mills, I'm going to put this question directly to you. How many times has this technology been procured through shared services?
These tools ont été achetés on a fait.
We've done this since shared services have come into effect. We do an annual review with this.
The question I asked was, how many times has shared services contracted this technology out to different departments?
We don't subcontract to other organizations. We purchase the services, we buy the technology, which is accessible by all government departments. So,
and I'm hoping for a direct answer. You do what you've just described. How many times has this product been accessed and by how many departments?
Je vais devoir revenir avec ça parce que les ministères peuvent utiliser.
I'll have to get back to you on that because the departments can buy the licenses to do this. So I don't have any report that says which department used which tool. This is a tool that's available to all departments.
Donc j'ai pas.
I don't have this information, but I can check and see if it does exist to determine which department used which tool and at what frequency.
Okay. Going back to the contrast between this particular tool, a forensic tool, and the on-device investigative tools, which we studied here via the RCMP, would the RCMP have had to go through shared services in the procurement process, or would they just be a direct vendor as well, direct vendor as well?
It would depend. We do provide IT services for the RCMP, but typically anything that's policing action would be directly them through their normal contracting processes, potentially through public services and procurement. I'd have to verify that.
Do you have any insight into the procurement practices of other, or oversight into the procurement practices of other departments?
No, it's only if we're doing a shared service and providing the shared kind of licensing where we can get a cost benefit.
That suffices. Because I think it is worth noting, you know, have you ever, let me just put this question to you. Have you ever, through your work, purchased on-device investigative tools?
At Shared Services Canada, no, I can't think of a time in my career where I've done that.
Okay, that's important. Sir, when you were talking about the privacy impact assessments, and you had mentioned that your work had predated, going back to 1996, I think you even referenced BlackBerry. Is it safe to say, though, you're not using the same technology from 1996?
Yes,
So you're using new technology?
an evolution of what we used back then, yes.
But I think it's pretty safe to assume, given Moore's Law, it would be leaps and bounds beyond the technology of 20 years ago. Is that correct?
Yes, in both the ways that we can access the data. Before it was all or nothing, and now we can actually slice and dice and choose what we see. But yes, it is
Much more
quite
powerful
different.
technology?
Yes.
Yeah. Would it be a material difference from the technology that you would have used in 1996?
Well, we didn't have telephones, and these are really in line with telephones. So if
It's completely different then, if that's the case.
Yeah, it would have been computers.
So new technology.
And I would base more on the actual technology, based more around the arrival of BlackBerries and flip phones,
Sure.
where we did process those in 2009, 2010.
But to my point, now in 2024, we're talking about an order of magnitude of technology beyond your first initial implementation. And the reason why I bring that up, I'm concerned when you say that our program predates the directive, because I interpret a directive from the Treasury Board to be a directive for all departments. And when we have departments kind of pick and choosing when they are under the kind of auspices of a privacy impact assessment, which I'll just go ahead and state, all of this could have been avoided, in my opinion, if these departments had just followed directives and done the PIAs. And so what we're left with as a committee is contemplating what the remedies are, which is to make a legal requirement of departments. So is it your opinion, or how would you respond to a question that states, would making this a legal requirement provide you with clearer guidelines as to the applicability of the PIA and the use of your technology?
Yes. I think the answer is yes, because we worked with new or substantially modified, and we work with this. We don't work on an island. We consulted with Department of Justice, and is our program, modified to a point where we need a PIA, and we don't. I mean, we make the decision with the information we have, so more clarity.
If I could, I think the challenge is that by allowing each department to opt in or opt out of the PIA, we're creating, I think, an unnecessarily kind of conspiratorial outlook on the way in which the stuff is used. When I hear the explanation about there being a crash and there needing to be a forensic audit of the data, that makes complete sense. There would be a lot of rationale for why you would use this information. I am not here today believing that you're spying on all Canadians and believing that there's some kind of nefarious thing with this technology. I believe that to be the case with the on-device, by the way, but that's a whole other conversation.
Mr. Green,
pertaining to this study.
You're over.
Oh, I thought you said I had 2 minutes.
No, I said 25 seconds.
Oh, geez, you see that? That's okay. I'll have another round. That's okay. I missed the 5.
I thought you might have been confused by that.
I thought I saw the 2.
Okay, so that concludes our first round. We're going to go to our second round now, starting with 5 minutes. And Mr. Brock, you'll have 2.5 minutes coming up there, Mr. Green. Mr. Brock for 5. Go ahead.
Thank you, Chair, and good afternoon to the witnesses. Thank you for your attendance. I apologize I wasn't able to hear your opening statements. I trust some of you probably did. I want to focus on this ArriveCAN scandal that seems to be dominating the House of Commons and Canadians from coast to coast. And following up on my colleague, Mr. Keurig, I'm going to be focusing in on you, Mr. Jones. It appears that you have some expertise in this particular area when it comes to technology and data and things of that nature. So at the heart of the scandal, and this may be news to you, is information. It's a lingering question that the Auditor General labored with, that despite all the material that she received from the CBSA, which didn't amount to a lot, given the shoddy paperwork and record keeping, is she was unable to determine who chose this two-person firm who received essentially $20 million of taxpayer funds for doing absolutely nothing other than connecting the CBSA with IT professionals. We have evidence to suggest that information was withheld from the Auditor General, and the information centers around one particular individual by the name of Min Doan, who happens to be the Government of Canada Chief Technology Officer. So one would think, just the label, Chief Technology Officer, that person would possess the necessary skills to retain records. But at the heart of this, mysteriously, he had 4 years' worth of relevant emails during the pandemic, when the cost of this Arrive scam scandal ballooned to over $60 million, 4 years' worth of emails constituting close to 1,700 emails in total just mysteriously disappeared. How can that happen?
Without knowing the circumstances, I can come up with a lot of different scenarios in the IT world. It could be something as simple as, and I've had this happen to me, the hard drive on my laptop failed and I lost my email. So without the specific circumstances, I don't know how to answer your question.
Okay. So that's been a lingering question. He's offered no explanation as to why he could not retrieve 4 years' worth of emails. Despite his status, he was the vice president of the CBSA at the time. He was the chief information officer as well for the CBSA. He's unable to explain that discrepancy. So the CBSA president was unable to really shed any light as to the content.
Mr. Brock, we have a point of order from Ms. Khalid. Go ahead, Ms. Khalid. I've stopped your time. You have 2 minutes left. Go ahead.
Thanks, Chair. We're just questioning relevance. I understand that the topic that Mr. Brock is highlighting is in study in a number of different committees. We are here on a very specific issue about the surveillance of government employees through government technologies with departments, and I would prefer, and I think that the community would appreciate if Mr. Brock stuck to that topic.
Well, as I've said in the past, Ms. Khalid, that I do give a lot of latitude to members to ask their questions, and I expect that they're going to come back to the topic at hand, and I'm certain that Mr. Brock will. He's done it before, so the floor is yours. You have 2 minutes, Mr. Brock. Go ahead, please.
Thank you, Mr. Chair, because I certainly don't frame my questions at the preference of the Liberal Party of Canada. Yeah. All right? So I know they want to shut this down. I know it's important for them to silence us,
Point of
but I
order,
will not be
Chair.
silenced.
Absolutely unreasonable.
Okay, thank
Come
you.
on.
Thank you for the point of order. Mr. Brock, please continue. You have the.
Thank you,
I
Chair.
did stop your time. I'm starting it again. You have a
Thank
minute
you.
and 50 seconds.
So, Mr. Jones, I want to know what tools potentially the RCMP, who may be charged with the responsibility of investigating criminality surrounding this Arrive scam. I can think of, hearkening back to my days as a Crown attorney, what's jumping off the page is allegations of fraud, allegations of breach of trust by public official. So in your professional opinion, sir, what sort of forensic tools would be available to the RCMP to retrieve 4 years' worth of relevant emails from the Vice President of the CBSA?
My issue, I honestly have never been privy to any of the investigative techniques that the RCMP use. We've always kept them at arm's length as the IT service provider. We certainly provide them with the base IT.
What kind of tools would you adopt then? If, say, for instance, Erin O'Gorman, the president of the CBSA, actually took her job seriously and wanted to retrieve these emails, what sort of tools could you adopt?
So if my colleague was asking for advice, certainly that's what we've established these contracts for in terms of the tooling that are required to retrieve information from government-owned devices. And there's a variety of tools depending on the type of device that would be used. I don't have a product list in front of me. I don't memorize, I actually never used these tools in my career.
Possible to retrieve 4 years' worth of emails?
It depends on the circumstances where they're located and how you would have to go about them. It's always very dependent on the circumstances.
Specific.
Yes,
Case specific.
very much.
Okay.
Thank you, Mr.
Thank you.
Brock. Thank you. Ms. Khalid for 5. Go ahead.
Thank you very much, Chair. Appreciate it, and thanks to the witnesses for being here today. While the Conservatives try to figure out whether they think that surveilling government phones is a good thing or a bad thing, I think perhaps I'll turn to you, based on what they think is good for them for chasing headlines. What I would ask you one by one, I'll start with Mr. Jones, is what do you think is the purpose of a privacy impact assessment, and how does that impact the work that you do in your department?
Well, I think for me, the privacy impact assessment hits multiple points. I think most primarily it's to ensure that we've struck the appropriate balance between the objectives that we have to do, for example, in the course of an administrative investigation, to protect the information and also follow through on the kind of the responsibilities that are conferred upon us in government with the privacy rights of our employees, and to make sure that we've gone through and done a thorough evaluation to make sure that we understand what those implications are, and we've either put in controls in place or we found a way to balance should we need to use a tool that's a little bit more invasive than we would like, to make sure that we found a balance. So, for example, that's why we put it in a lab, in a secret facility with security-cleared people, very limited access. Like, I can't open the forensics lab, for example. I can't go into it.
Thanks for that. So the Privacy Commissioner has said that obtaining judicial authorizations is not a replacement for privacy impact assessments. So where do you, I mean, in your opening remarks, you talked about, the fact that you have to get the warrants before you have those invasive procedures done. Where do you stand on that? Mr. Jones.
We are not a law enforcement agency, so we have no path to obtain a judicial warrant. We do this under my authorities under the Financial Administration Act as the deputy head to conduct administrative investigations. But like I said, those are very limited in terms of scope, and these tools are used when it's necessary and they're required. So I'll give an example. We're not Shared Services Canada employees. We do not take our phones out of the country. If the phones or laptops, et cetera, if they are taken out of the country, we use these tools to confirm that there was no documents that were taken from the device, that there was no malicious software installed, et cetera. It's used to confirm our security status and security setting. That's an example of where we'd use these tools.
Thank you. Mr. Mainville, same two questions, if that's okay with you.
So the PIA, for government agency, it helps us balance our program and our responsibilities to enforce the Competition Act with privacy needs of Canadians. So that's what the PIA is. So the primary goal is to systematically assess and proactively address any potential risk associated to new or modified programs.
Thank you. And Ms. Fox?
Yes, so we agree with the Commissioner. It's not a replacement. Obtaining consent does not replace the obligations to have a PIA. We have a PIA since the program was created. We have updated it through some of the years. And the PIA covers the data that we collect. So we ensure that all the data that we collect is covered in our PIA and assessed against the privacy concerns. After discussion with the Office of the Commissioner, we agree with the office that based on where we're at, it would be a good idea to update that. So the tools don't make for a PIA. Just because you purchase a tool doesn't necessarily change the way you use the data, and that's why it wasn't done with as a PIA for the tool. But certainly we believe that it is appropriate at this time to update our PIAs, especially with some of the new direction that's coming out from the Treasury Board on this aspect.
Thank you. I appreciate that. And coming back to you, what more can you do to engage with the Privacy Commissioner to ensure that trust in public institutions is maintained, especially when there's intrusive technology on people's phones that are employed by the government?
Well, again, we are not using the tool that was mentioned in the report in any way to interact with employees' phones, government issued or otherwise. We're only using the tool to extract data under our mandate for the purposes of conducting our investigations, and only the relevant data that we need, and the device is returned intact to the owner. So, and again, we've put this under appropriate security measures in terms of standalone computer, limited access, and proper use of retention policies and so on. So, and we have engaged with the Privacy Commissioner as recently, the Office of the Privacy Commissioner as recently as last week to just reconfirm our position on this.
Thank you. And Mr. Jones, same question.
It's a quick response, please.
I actually have met the Privacy Commissioner. It was one of my first things when I took over this job, and it's to talk about how do we start to look at emerging technologies. This is one of those areas where, frankly, it's a best practice that we should have implemented, and that's why we're doing one now.
Thank you, Mr. Khalid. Mr. Jones, Monsieur Villemure, pour 2 minutes et demie. Commencez, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Chair. Mr. Jones, are you relatively new at Shared Services? No, I don't think so. Mr. Mainville, going back to what my colleague said, the ability to take action, well, this has changed since 1996. When we talk about PIAs, it's a program and all that, we know, but is it viewed as being something that's too complicated or not important, or something we'll do tomorrow? Well, what factors are taken into consideration? An assessment's done to determine whether a PIA is necessary, and during the assessment, we assess the change in what we're collecting and how we process what we collect. And as I mentioned earlier, with the testimony provided by the Ethics Commissioner, we contacted the office to ask for advice. You have remained in contact with the Ethics Commissioner because I would lead you to, I would like to ask you about another tools. We're not talking about the same tool here. Is when you put a microphone in a lamp in the old days. We're not talking about the same thing. The expectations for privacy today are different. I congratulate you on going ahead with this, but I'm disappointed that that there are so many departments that have not done so. Mr. Mills, how many departments and agencies have used this device? Could you reply to us in writing and provide us with an enlightened decision? Thank you, Mr. Chair. 30 seconds. Ms. Fox, you said I only use it during an investigation and for specific cases. The fact that you're conducting an investigation, does that mean that you don't need to use a PI? No. We do have to comply with the Privacy Act, and however, we are entitled, according to the Act, to collect information as part of our mandate to conduct investigations, but we must also have to share this information and use it only to determine what happened. Don't these two acts contradict each other? No, I think we always need legislation that's specific, particularly with respect to transportation safety investigations. We can't find out what happened in order to prevent other accidents from occurring if we don't have this. So we have to weigh the public interest. That's important. With the Privacy Act. It's a question of striking a balance. Thank you, Mr. Villemure. Mr. Green, I'll give you 3 minutes.
And I've started my timer, so I'll make sure that I know it. I'm going to ask 2 questions to all of you, and the questions will be the following. In the case where you're using a tool on a mobile device or computers that your employees do access, just your opinion, do you think that it would be judicious for your institutions to consult the OPC before deploying that use? And secondly, would adding a legal obligation to conduct PIAs and to submit it to the Office of the Privacy Commissioner of Canada in the Privacy Act make the process clearer for your institution, and in particular for government institutions in general? So both for your department, but for all departments. My hope in asking these questions is not a gotcha. It's to hopefully have a report that provides us with clear recommendations to the government to improve the processes so you all don't have to be here again for these types of scenarios. So we'll start here.
Yes, in terms of using this technology for employees, yes, of course, we would consult with the Office of the Privacy Commissioner, as this would be a total new use, and I don't really foresee us ever doing that. In terms of your second question, I think that the better mechanism to get to what we need is more awareness and training of employees. And I think this committee is doing a good job by actually holding these sessions of bringing that awareness up front. I think the directive is being reviewed, and if we can add awareness and training to that, I think it would go a long way, more than
I do have to go on to the other departments. Thank you.
From my perspective on the administrative investigation side of things, I think it's important that we continually update our processes for adding in best practices, learnings from other departments, and consulting the labor relations experts at Treasury Board. But certainly having the advice of the Privacy Commissioner there is important in terms of the establishment of the program. We use these tools very rarely in that case. For the access to information and privacy side, it's important to note that once these records are under the control, this is about us responding to the legal obligation. And so we use those very restrictively. But for example, every once in a while we get a request for all of the text messages sent from my phone. we use this tool to get them.
Those requests often come from this committee.
And so it makes it quick. And it's because it's very hard. I don't actually,
Okay.
I can tell you how to get them off of my phone.
I appreciate that. I do have to go to the last department.
For your first question, we are a law enforcement agency. We do have Section 29 of the Competition Act that requires us to conduct our investigations privately. So that's the beginning of the privacy. So it'd be very hard for us on a transactional basis to go to the Commissioner of Privacy. And for the second question, yes, I think it would be beneficial if we, we're all expected to do PIAs on our programs, not specific tools. And then when those tools change, if they drastically change, revise the PIA. So
Established that your tool did drastically change from 96.
and we are looking at establishing a PIA.
Thank you.
Okay, thank you, Mr. Green. Two more 5-minute question rounds. One for the Conservatives, Liberal, Mr. Kirk. 5 minutes. Go ahead. Start now, please.
Thanks very much, Chair. And so to the folks at Shared Services Canada, one of the companies in question here is Celebrate, and I know there's media reports about how both the technology can violate privacy, but also they've had a tech breach, and I think it's 1.7 or so terabytes of data of information that was made public. So I'm curious to Shared Services Canada, one of your big roles is being able to provide, in this case, a very powerful tool. What processes do you have to make sure that the tools that you're procuring actually respect the rights, privacy of Canadians, both those that might be used outside of the administrative purposes of government for the purposes of investigations, whether that be our other agencies that we have here or others this committee has heard from, or for administrative purposes, making sure that a company that has some pretty serious accusations against it, that privacy and rights are protected in that process. What is your process?
So I think there's quite a few elements to that question. I think the first piece is when we're procuring, we procure for requirements, so we need a certain capacity or capability to do some aspect. And so that's what we'll look for. As part of that, there's also a security assessment that's done. So we work with our partners at the Communication Security Establishment to do a supply chain integrity, make sure that the ownership. But then lastly, it's how those tools are used and how we deploy them. So for example, any tools like this we use in an isolated lab, so that way the data stays under our control, it stays in our physical possession, and it stays in a physically isolated as well.
So is that like a protocol that you've set up?
So that's for us. So that last step is for us as a department. How we do the evaluation of the software is a standing process for how we're working with the Communication Security Establishment.
When the article first came out with some revelations and some real serious questions, and a lot of questions, and we've been able to answer a few of those. And again, I'll just recommend proactive privacy impact assessments. And with respect, all of you operate under acts that were passed by Parliament, and the Privacy Commissioner is an officer of Parliament. So utilize that service because government is a function of Parliament, not the other way around. But so those are protocols you've created to ensure that this technology is used within that, a secure room, not connected to the internet, that sort of thing. That's what Shared Services Canada has done.
That's what we've done in terms of administrative investigations, but any forensics assessment, yes.
Okay, so I am curious. There were 13 departments and agencies referenced, some of which there's no surprise, the TSB, for example, RCMP, et cetera. But then there were others where there's outstanding questions and just where we don't know whether it was for administrative purposes, et cetera. Are there any additional departments to the 13 referenced in the article that have utilized the software that you have through Shared Services Canada? Are there other departments that would have utilized that software beyond the 13 referenced in the article?
I don't have a list. I don't know, Dan, if you have seen anything. I don't think so, though.
Yeah, I don't think so, but as I mentioned earlier, we can provide to the committee the list of all departments that have used, if they are in addition to the 13 that were listed in the article.
And if I could ask as well, it would be helpful, because I think there's two very distinct things, right? There's the administrative side of things, ensuring that employees' rights are protected and whatnot, and then there's the investigative side of things, where whether it's because of an airplane crash or a competition circumstance like our other guest here. So if you could delineate the difference between those circumstances where it was used for administrative purposes versus those for investigative purposes, I think that would be very, very helpful. And further, it would be nice to know about judicial authorization, but I suspect that probably goes beyond the mandate of what shared services would be able to provide. Am I correct in that assumption?
I don't think we would know the purpose of the tool other than making a guess at the mandate. I think it's probably best we can certainly look at which departments or agencies have procured through us, but we wouldn't know what purpose they were using it for. So I wouldn't, for example, the RCMP was not going to tell me what tools they use in a police investigation.
You're the IT service providers who need to get answers. So if you could provide that information, and both, if you know about the administrative purposes versus investigative purposes, that would be very helpful for us to answer some of these, what are still serious outstanding questions I think that many Canadians have.
Thank you.
Thanks.
Mr. Baines, for 5 minutes. Go ahead, please.
Chair, and thank you to everybody for joining us today. My first question is going to go to the Competition Bureau. I was just interested, you talked about, you indicated some of the duties that you perform. It's about, and you talked about bid rigging, price fixing, things like that. You investigate those things. So would these tools be used in an investigation of that manner?
Yes.
Okay, so like if you're trying to combat price fixing or anything, bid rigging, those kinds of things, someone of interest would come, you would have, and as a law enforcement agency, you would target, and then you would still need to get the judicial consent to go after and investigate and then use these tools to go do your work.
That is correct.
Okay, so if so like in Canada, I think we have a challenge with oligopolies. We have, for example, grocery, telecom companies that we look at, and ultimately they control pretty much the market, small group of large companies. So, for example, like groceries, I mean, we even heard in House of Commons that, if a certain person was in charge of, say, grocery prices or something, that they could come down. Would that be something that you could look at?
Well, I'm going to turn to my colleague, Yves.
It's certainly allegations that we can look into, that's for sure.
So a complaint would come forward, et cetera, and what would be the process that would go through?
So our processes are very similar to what the police could do in terms of investigation. So we get some certain information. It could be like one of your constituents that could complain to us, for example, bring us some information. If we have enough information to pursue, we will start, let's say, like using our own tools in terms of investigations. So searches, for example, if we have the grounds to do this, and then let's say we seize a cell phone from one of the targets, then these tools would be used.
And then from the cell phone, you can extract. These tools can do what with a cell phone? What can you extract? We saw some demonstrations in previous meetings here. So you would need to obtain the phone, connect to it, and extract everything that they have, right? So that would you have access to all the apps and everything in there?
We would have access to everything that's in the phone. We do have processes so what we'd be interested in a case of bid rigging is has that individual, communicated with somebody from the other company to set prices. So those types of communications. We do, and it's been mentioned a lot in this study so far, we do have processes where only relevant information make it to the case file. So if you see me as the forensic person, I would only give information to my colleague Pierre-Yves, who's the investigator, that is relevant to his file. He would not get the whole address book, unless he's got reason to believe it would be really restricted to what was outlined in the search warrant.
So the search warrant would have to be very specific, pinpointed, and then only he would have access to it. And how many people in your department have access to all this? Like, investigative people are there?
So initially, when we come back from a search, the people who have access to the images of these telephones would be the 8 to 10, depending on our complement at the time. Right now, 8 forensic practitioners, and only the relevant data would then be made available to the case team, and only the case team. So similar to other law enforcement agencies who have testified, this is not made available to all of Cartel's directorate. It's made available to the case team investigating that one matter.
And then you would be alerted if somebody else was to come in and look at that information. You have those mechanisms in place?
Yeah, the computer forensics is what I've heard called an air gap network. So it does not connect to any other network, not the internet. It is within a secured room, inside a secured room with restricted physical access.
Okay.
You just went over your time there,
Thank
Mr.
you.
Baines.
Thank
Okay.
you very much.
Thank you, Mr. Baines. I want to thank our guests for being here today. There has been some requests to undertake some information to the committee. Clerk's going to follow up with you, but I would like that information in the hands of the clerk by 5 o'clock next Tuesday, if possible. That's a week from today. So, as I said, the clerk is going to follow up. So I want to thank all of you for being here today. I'm going to dismiss you. We do have some committee business that we need to discuss. Thank you so much. So on to committee business, members. I understand that there is an interest in taking up an offer from the RCMP to have a technical briefing in their facilities. Mr. Motz, is that something you'd be interested in? Absolutely. As a former RCMP officer. So if there's, I see your hand. So, huh?
Can we ask that Glenn lead the tour?
Yeah, in Alberta. There's two options that we have here. Number one, we can make a formal request, which means that we have a deadline by the 16th to make that request to Liaison Committee for approval. The other option that we have is to make it an informal visit to the RCMP, which I understand is the desire of the members. I want to make sure that the circumstances of that are clear, and that is that any informal visit to the RCMP to discuss the issue of privacy collection, et cetera, cannot and will not make it into the report. Okay, so there's nothing that can come from that makes it into this study. It's just as a matter of interest for the committee. So, Ms. Damoff, I see your hand, Mr. Brock, and anyone else. Go ahead, Ms. Damoff, on this issue.
Yeah. Thank you, Chair. I did have a conversation with Brian Larkin after the last meeting and with Michael Barrett, who's not here right now. But with the Public Safety Committee, and Glenn, I think, we went to the gun vault in an unofficial capacity just to learn more about the issue. And I think Brian has offered to educate us more on privacy and cell phones and what they're able and not able to do. My concern is that if we go the formal process, Chair, it takes quite some time, assuming it even gets approved, and it could be June before we get approval to go, and at that point we've already finished the study and moved on to other issues. So I'm happy to coordinate this with the other 4 parties. It would be, it's here in Ottawa, so it doesn't require transportation. The RCMP is able to conduct these tours in 2 official languages, so we don't get into issues of it being not having access in French. So that would be our recommendation, Chair, and I'm happy to coordinate it with Michael.
Thank you, Ms.
And the others.
Yeah, and just for the benefit of the committee, the headquarters are in Orleans, so it's not too far away. Mr. Brock, your hand was up, and then Mr. Kerr.
Yeah, I wanted clarification of the site. That's been answered, and I wholeheartedly agree with Ms. Damoff. That's the right approach to take.
Okay, thank you. Mr. Kurek, suivi par Monsieur Villemure. Go ahead, Mr. Kurek.
Yeah, thanks. And I had a quick chat with Michael, and I understand that there'd been some discussions here. I think informal certainly is best, and it doesn't have to cost taxpayers a penny. We can do this, and I would just note that and on the record as well, just that if there was information that became relevant to the study, I think it would be entirely appropriate for us to request that the RCMP provide it in a follow-up. So although the tour itself wouldn't necessarily be on the record, certainly the information that we learn could be included in what that future report, and especially I appreciate that the RCMP has extended this opportunity for us to help understand these tools. So.
Okay, thank you, Mr. Kurek. I'm sensing that there is consensus among this to be an informal trip. Monsieur Villemure, s'il vous plaît.
Oui, Monsieur le Président,
Mr. Chair, I just would like to table the last version of my motion. Go ahead. That pursuant to Standing Order 1083H, the committee undertake a study of misinformation and disinformation and their impact on the work of parliamentarians, that the committee devote the next 3 available meetings to this study, that the committee invite experts in the field of misinformation and disinformation, and that the committee report its observations and recommendations to the House. So the motion has been moved by Mr. Villemure. I agree with that. You have already submitted a notice of motion. Do you have something that you would like to say with respect to the motion? Thank you, Mr. Chair. When we consult studies on disinformation, there's concerns about everything, including climate change. We in Parliament have to make decisions, and if we can't make enlightened decisions, well, we have to make enlightened decisions, and we ourselves can be the target of misinformation. So I think that in order for Parliament to make more enlightened decisions, this study, which should be done with expert testimony, could help us to proceed and do our work better as parliamentarians. Thank you. Thank you, Mr. Villemure. Just to clarify, committee business. We're going to begin the study we are already dealing with, and you're talking about a future study. Is that correct? Okay. Thank you. I just wanted to clarify.
Followed by Mr. Green, and then I see your hand, Mr. Barrett. Go ahead, Ms. Khalid.
Thank you very much, Chair. And I really, through you, Chair, I want to thank Mr. Villemure for bringing this motion forward. I sit on the Commonwealth Parliamentary Association as Vice Chair, and in our discussions amongst Commonwealth countries, this is the #1 issue amongst parliamentarians across the world, is how do we deal with this misinformation, disinformation, how does it impact our democratic institutions, and how does it impact how we make decisions. So I 100% agree with Mr. Villemure as to how important this issue is, and I would hope that we would spend a little bit more time than just 3 meetings on this. I think that we do need to do a deep dive into how we can make sure that governments are prepared for the changing face of technologies, for the changing face of digital media, and how it impacts the spread of information and misinformation, disinformation. I can come up with at least 10 witnesses on this issue that I think would be great contributors in terms of coming up with recommendations as to how we can, as the Canadian government, deal with this issue to provide not only safety and security for Canadians in the information that they are absorbing at such a fast rate nowadays, but then also to ensure that the information that we are taking in is accurate, it is honest, it is objective, and it is not nefarious in its objectives as well. So I would really appreciate if, with the consensus of the committee, if we could say at least 3 meetings on this, and after those 3 meetings, come back to it and see, how many more witnesses we have that would be interested to speak to this, how much more information or areas within this topic that we need to dive into a little bit deeper and reevaluate where we would like to go with this study. I think, and I really congratulate Mr. Villemure for bringing up this very, very important topic. I think we really need to do that deep dive. So I would friendlyly, if that's a word, propose, that we say at least 3 meetings and reevaluate at the end of those 3 meetings. Thanks, Chair.
Okay, I'm going to take that as a formal amendment. It's difficult on a friendly basis to amend motions, but I'm going to take that as a formal amendment and then seek, if we do have consensus on the change that Ms. Khalid is proposing, and that is at least 3 rather than 3. Okay, so we're still on the amendment. If anybody wants to speak to it, I'm just going to see if we can go ahead, Mr. Barrett, on the amendment, changing 3 meetings to at least 3 meetings.
Yeah, 3 is fine. I just wanted clarification also on the motion that's being amended. So is the understanding that as it's worded,
3 available meetings. That's what yeah. So I wanted to make that. I wanted to clear that with Mr. Villemure that it doesn't. Next 3 available meetings. Okay, next 3 available meetings. We do have meetings scheduled, which I'm going to touch on after we dispose of this. But next 3 available is what Mr. Villemure is proposing. Okay. Okay. So I'm going to seek consensus on the amendment. If there's no further discussion, at least 3 meetings. Are we all in agreement? Okay, we see that. Now we're back to the main motion. I've got Mr. Green. Main motion as amended. Mr. Green, go ahead.
Thank you, and I again appreciate the good work of my friend from the block, Renee Villemure, for setting the course of our next study. I'm going to just put my cards on the table and say that I am satisfied with the study, with the outcomes of the study that we're currently in. I get a sense that we could ask 8 more departments and we'll get very similar answers. I am satisfied that this is not an on-device information technology or spyware or malware. I am satisfied that it is used within the regulations of the respective mandates of the departments for investigative tools, for audit tools, and I'm satisfied with the parameters in which they're using it. I'm not satisfied with the lack of the PIA, which I've expressed. Having said all of that, Mr. Chair, how many more meetings were we scheduled for that particular study? And would it benefit the committee to perhaps move a motion to direct the analyst to begin a draft report on the work that we've already done to date on it?
Okay, so I was going to update you. It's perfect timing for that. If you can give me that sheet, Madam Clerk. So we've got 1 more meeting on this, okay? You expressed a desire to have the unions come in and discuss this in terms of the public service. So we've arranged on Thursday to have the Canadian Association of Professional Employees and the Professional Institute of Public Service of Canada come in. Unfortunately, PSAC has declined to come in. So they are coming in, and then one of the witnesses that Mr. Villemure wanted to see was the source of the CBC Radio Canada article, and he is coming in on Thursday as well. And thank you for reminding me of this. We have the president of the Treasury Board who's committed on March 21st. So that will effectively, tie this study closed, and that's where we're at. So
my next question would be, when would be the next 3 available dates?
Well, the only thing that I can see right now would probably be February 29th as a start of this particular motion if it does get passed, because on the February 27th we've got the the commissioner of the RCMP coming in on the on SNC Lavalin. So that would probably sorry, just let me just give me a second. Yep,
It
yep.
is going to be a heavy issue.
Yeah, so the clerk just reminded me again, and this is, I was talking to Alexandra about this before. We've got the RCMP commissioner coming in on February 27th, and then we've got the draft report that will be available on the social media study on by February 19th. And as it stands right now, I'm calculating probably up to 3 meetings on that. It could be less. I'm hoping it'll be less. There are a few recommendations on there. Hang on, Damien. So that's sorry, I see you, Mr. Curry. Yeah. I'm on a roll here, so that's where we stand right now. Unions and Mr. Villemure's guest on Thursday, break week, February 27th, RCMP Commissioner, February 29th might be the earliest, or well, I anticipate that we're going to start the draft report on the social media study at that point. And then March 21st is the president of the Treasury Board. So it's not likely that we're going to get to this. And then we've got break weeks in the month of March as well. So we may not get to this until we're back from the majority of those break weeks. Okay, good. Okay. Okay, so Damien and I answered you. That's why I was on a roll. I was on a roll. The only problem is I didn't do it in French, Renee, and I'm sorry. Okay.
Well, Damien was interrupting.
Okay, so rudely interrupting. Okay, so we are on the main motion as amended, and I'm going to ask if there's consensus on the main motion as amended, or do we want to go to a vote? We're fine? Okay, so the main motion as amended passes. Merci pour la motion, Monsieur Ville.
Thank you for your motion, Mr. Villemure. I had
It's National Kindness Week. I would just like to make note of that. Okay. And as the House of Commons sponsor for National Kindness Week, I would just like to take this moment to wish everyone a happy National Kindness Week, and just, with this motion passing unanimously, it's just a good sign of the wonderful possibility of our great country.
Let me interpret that for you. Mr. Barrett will be proposing a motion at some point. I don't know when that's going to happen, but he's going to look for the same type of kindness, okay? So, anyways, I don't see any other business. Thank you to the clerk, analysts, and technicians, and I'm going to adjourn this meeting. We'll see you all Thursday.